All right, ladies and gentlemen, chapter 11, and we're going to talk about civil and criminal remedies for constitutional violations. So, in chapter 10, we talk about the exclusionary rule. So, the exclusionary rule is just a means of excluding any illegally obtained evidence, whether it be contraband or something they've confiscated, or even some type of admission or statement they're trying to use against you. If it was obtained illegally, there's a means of keeping it out. Now we're going to talk about in this chapter what else you can do if your rights have been violated outside of excluding evidence. As an introduction, the exclusionary rule does not provide individuals with an adequate remedy in every instance in which their constitutional rights have been violated. Sometimes the cops go overboard and there has to be more done. Individuals who claim to have been deprived of their constitutional rights also may file civil actions in state or federal court for damages. The police officers may also be criminally prosecuted before a state as well as before a federal court. Civil remedies. Individuals who claim that they have been deprived of their constitutional rights by the police or other law enforcement or public official may file civil action and ask for damages as well as an injunction. An injunction is a civil remedy where the court is ordering someone to do something or to stop doing something. So either you stop doing something, which is a cease and desist, or they can order you to do something or bring something to court. That's what we call an injunction. Um, so, United States Code, and so anytime we say in the book, you see USC. That means United States Code. That's the federal code. So, in other words, it's federal legislative made law that's been codified and put in a book and coded so that you can find it. So that's anytime we say that a law's been put on the books, or that's essentially public notice. So it's in a public book for you to find. So that means it's law. So you have been notified whether you decided to read it or not. So 42 United States Code Section 1983. So that's not the year. That's just the section number. But Section 1983, as I'll say from here on out, you hear me say 1983, I'm referring to the section of the code. But it provides a remedy against state and local officials. They also call it a Bivens Act, a Bivens action. A Bivens action may be filed against federal officials as well. Section 1983 legal actions against local and state enforcement officials. The United States court interpreted the Ku Klux Klan law of 1871. Also, Section 1983 of the United States Code 42 to apply to police officers and other representatives of the state who deprive individuals of their constitutional rights. The plaintiff must establish by preponderance of the evidence. Now, we learned that there are differing burdens of proof. So this is civil when you're filing a lawsuit. So when you're filing a lawsuit against somebody, you have to prove that they did something wrong by preponderance of the evidence. So it's no longer what we call beyond a reasonable doubt. So it's not guilt or innocence. It's just liability or no liability. So in other words, are they responsible, and do they have to owe you a damage or have to pay you back? Um, but it must be established by a preponderance of the evidence. Three elements: one, that the defendant acted under color of state law. So the defendant in this case, in the civil case, is law enforcement, whoever the agency is. So were they acting under color of state law? We'll talk about what that is later on. Two, that they violated an individual's constitutional right. So did they violate the right? And then three, that the constitutional right was clearly established. So three things. So that the actor or the law enforcement official was acting under color of state law, that they violated a right, and that right was clearly established. So in other words, it was obviously a right. You know, they know, we all know that you had that right. The Supreme Court has held that this test is not mandatory. A court may simply examine whether an individual acted under color of state law and violated a constitutional right that is clearly established, which says the same thing. Um, Color of state law. What does that mean? An individual acts under color of state law when he or she acts under the authority of state law. So, in other words, they're acting in their capacity as a law enforcement officer, and they're holding themselves out to be as such. So, whether I'm a plainclothes officer undercover, or whether I'm not on duty at all, if I'm going into a situation and I'm asking you to do things, or I'm doing things because I'm a cop, whether I'm on duty or not, I'm acting under color of state law. So I'm using my authority and my position to try to make you do something or make you give me something or do something against your will. And I'm saying, I'm telling you to do this. I'm telling you to do this, and I can because I'm the police. That is color of state law. Um, a wrongdoer is considered to act under the color of state law, even when he or she goes beyond the limits of his or her lawful authority. So, as long as you're in color of state law, it doesn't matter if you cross the line or not. You're still acting under color of state law. Um, the determ and determining whether off-duty police officers were acting under color of state law, judges look at the totality of the circumstances and ask whether the off-duty police officer's acts were undertaken in furtherance of his or her responsibilities as a police officer or were undertaken as a private citizen. So we have to look at the totality of the circumstances. If I'm just being a neighbor and I say, hey, stop, even though I'm a cop, I may not be acting on the color of state law. But if I hold myself out to be as such, even if I'm off duty, that may be color. We look at it under the totality of the circumstances to determine whether or not I'm acting under color of state law. Now, violation of federal constitutional and statutory rights. The second step in the 1983 case is in legal action is to establish that the defendant violated a right guaranteed by the United States Constitution or by or the federal law. So that's usually easy. You can say, well, they violated my right. They searched my house without a warrant, and it was unreasonable. So you can usually establish that. So you have to establish that the actor or the person you're suing um, acted under color of state law. And for second thing is that they violated a right. Individual liability under 1983. That means so usually when you're filing these lawsuits, if the Greensboro police does something wrong and I file a lawsuit, I'm probably filing that lawsuit versus the city of Greensboro under a federal action. But of course, because the police department is a part of the city of Greensboro. But what about individuals? What about that police officer? Liability under 1983 may be imposed on the officer who is directly responsible for violating an individual's constitutional rights, as well as on his or her commanding officer. A supervisor may be held liable where there is an affirmative link between the supervisor and the misconduct of the officers. So that's a good thing to know as well. Then we have immunity, certain types of immunity. So everyone can't be sued under a 1983 federal lawsuit. So we have absolute and qualified immunity. Judges, prosecutors, witnesses, jurors, and other individuals have what we call absolute immunity for decisions in the courtroom and may not be sued under Section 1983. The police and other criminal justice professionals have qualified immunity. They may be sued and held civilly liable only for the violation of clearly established constitutional rights. So, in other words, what qualified means is essentially limited immunity. So they can be sued, but usually there's an amount limitation sometimes, and then they can only be sued for specific things they did. So, in other words, you can't throw in the kitchen sink in a lawsuit. Um, the affirmative duty to protect. Um, the police have no legal obligation to protect the public and are not civilly liable for failing to protect members of the public from crime. So the police are essentially reactionary. They can't get there and save everybody. So because they didn't get there doesn't mean you can say, well, I'm suing the cops because I got robbed and they weren't here. It doesn't work that way. Um, they are legally responsible only for the harm to an individual over whom they have custody or for when they cause harm by their actions. So they do get to the crime scene or they get there before something happens, but because of their presence or how they react, they actually cause a damage. Courts developed a state created danger exception. This is what I just said to the rule that a government official will not be held liable for failure to intervene to protect the public. This arises where state action creates or exposes an individual to danger that he or she would not otherwise confront. So I'll read that again. Courts have developed a state created danger exception to the rule that what that means is if they create the danger by them being there, then now they are held liable and can be sued. Um, and can be sued for their inaction. Um, so the liability of local government entities under 1983. States and state agencies cannot be sued under 1983. The 11th Amendment to the United States Constitution provides for sovereign immunity of states from prosecution. Um, this immunity does not extend to cities, towns, counties, and local government agencies. The Supreme Court in Monell v. Department of Social Services interpreted the term individual in 1983 to permit plaintiffs to sue local cities, counties, and agencies. So, of course, that means you can't sue a state under Section 1983. Injunctions. Section 1983 also allows for injunctions against local government or government agency. The violation of an injunction is punishable by contempt, which may result in a fine or possible imprisonment. Pattern and practice of deprivation of constitutional rights. The Federal Police Conduct Misconduct Statute, which is section let me see, it's hard to say this. So it's section 14,141 or 14141 provides that it is unlawful for state or local law enforcement officers or law enforcement agencies to engage in a pattern or practice of conduct that deprives individuals of a constitutional right or of a right guaranteed by the laws of the United States. The U.S. Attorney General, when he or she has reasonable cause to believe that such pattern of violations exists, may ask a court to direct a police department to correct the practice. Now, how this has been used in modern days is actually in Ferguson, Missouri. I don't know if you remember in the Mike Brown situation. Um, they actually called for a federal investigation where the attorney general at the time, what's his name, Attorney General Holder, actually went in and they did an investigation of Ferguson, Missouri, and they actually found a lot of racism and systematic practices that violated people's constitutional rights. So they went in and, of course, changed things and gave them things that they had to do to kind of to now be up to code or up to standard. So that has been applied recently. So there have at least been investigations where they investigate and to see if there are any changes that need to be made. State tort remedies. Now, what is a tort, first and foremost? A tort is a civil wrongdoing. So sometimes torts and crimes can be the same thing. So it's criminal it's actually criminal to smack somebody. That's assault. But not only can a person that smacks someone be charged as a criminal, but they can also be sued for damages under tort law. In other words, you slapped me, you broke my glasses, so I want my money back. I want my hurt, my pain and suffering money as well. So that's where you get money from in tort claims. So state tort, so that's what a tort is. State tort remedies against law enforcement officers. State law enforcement officers may be sued in state court for torts. Towns, counties, and states, under some circumstances, may be held financially liable under state law. So remedies for constitutional violations by federal law enforcement officers. In 1971, in Bivens v. Six Unknown Named Agents, so in the Bivens case, the United States Supreme Court held that federal law enforcement officers are responsible for violating individuals' Fourth Amendment rights. Federal officers have been held legally liable under Bivens actions for violations of other constitutional rights, including Fifth Amendment right against self-incrimination and the Eighth Amendment right against cruel and unusual punishment. So individuals can be sued. Criminal, but that's under the Bivens case, and that's when we're applying that to federal. So always make sure you hear me when I'm telling you to hearing that I don't just say law enforcement in general. I'm always saying state, local, which can be different. So a state and a municipality are treated differently in a 1983 action. So remember, in 1983, you can't sue the state, but you can sue local. Like, so we talk about cities and municipalities; they can be sued, but you can't sue states. Um, so just make sure you hear the difference between federal law enforcement, state law enforcement, and local. Um, so where was that? Okay. In 1971, in Bivens, the Supreme Court held that federal law enforcement officers are responsible for violating um, individuals' Fourth Amendment rights. Federal officers have been held legally liable under Bivens actions for violation of other constitutional rights as well, including Fifth Amendment right against self-incrimination, and Eighth Amendment right against cruel and unusual punishment. So, of course, that's probably when they use deadly force. So your rights can be violated when deadly force is used because deadly force is a seizure. So if a person's killed and their rights are violated and being killed by a law enforcement agent, that agent can be held civilly liable and possibly criminally liable. We'll get to that. Criminal prosecutions. Speaking of which, state and local police officers who commit common crimes may be prosecuted in state court. Criminal charges also may be brought by Department of Justice against state and federal criminal justice officials for the violation of U.S. statutes, including laws protecting individuals' constitutional rights. In terms of federal constitutional rights, the prosecutions typically are based on a 1866 civil rights law. That's not the year. That's like the number. No, well, that is the year. The 1866 Civil Rights Law. Also, Section 242 of the U.S. Code that authorizes the prosecution of state or federal officials who act under color of local or state law custom with specific intent of depriving an individual of a constitutional right or of a right protected under federal law. Then you have administrative remedies. There are two major approaches to enforcing a police department internal regulation. You have internal affairs divisions of the police department that investigate misconduct. The punishment for violations of police regulations typically is imposed by an officer's commanding officer with the agreement of the chief of police. So they can actually be punished internally. It may be docking of pay or a limitation on the hours they can work, which affects their bottom line and their money, the paychecks they have to make. Civilian review boards and agencies are composed of private citizens with authority to investigate and in some instances actually discipline police. Now, Guilford County, our civilian review board does not work like that. They essentially just sit there and talk and ask questions, but they have no punishing power. They're purely advisory. Um, let's talk about internal affairs. The Internal Affairs Division of the Police Department is charged with investigating misconduct by police department employees. So, of course, that's the police policing the police, and they have their own internal means of punishing themselves or punishing other police officers. And it usually deals with docking pay. Sometimes the police officer can be dismissed, but it just depends. Um, Next, we have what we call external review or civilian review board. That's a review outside of the police department. Civilian review boards and agencies typically are appointed by the mayor or city council, and in most cases are composed of a cross section of the community. The boards typically apply a preponderance of the evidence standard, requiring that the weight of credible evidence establish that the officer engaged in misconduct. Civilian boards have different powers in various cities. In Greensboro, they have absolutely no power other than to advise. They can't actually punish police for individual things they do. They just sit there and listen and say, well, we think that was wrong. As a matter of fact, a lot of times they can't, in Guilford County in Greensboro, they can't even really speak outside of those hearings. So they're kind of closed. So there's really no public, at least embarrassment of police for what they do sometimes. So with that we get to the end of my brief recitation and just going over the major points of chapter 11. Of course, with all these chapters, remember, please read yourself, do your own independent study. I'm just going through the major points. I can't sit here and read the book for you in my lecture. So that being said, have a good evening. Take care.